We will be emailing out a link for the attendees and our members to come back to if you want to review this info at a later date. Second, we do have captions available for this webinar. Those can be turned on or off at the bottom of your Zoom window. We'll also have the transcription of the webinar available after we wrap up if it's needed. Please just send me an email at cstivers@kstc.com if you'd like a copy of that, and I'll put that in the chat in just a minute. And lastly, as we are hosting in the webinar format, participants are all currently muted. So you can place any questions or comments in the chat or Q&A area, or raise your hand if you would like to be unmuted. If they've not been addressed by the end of Tanya's presentation, we'll make sure to answer them before we end our webinar today, or we'll connect with you afterwards. So to get us started, today I have the pleasure of introducing Tanya Shapira-Barr. Tanya is a senior patent counsel at Vixness Harris Patties Mellon LLP with 12 years of patent law experience working in the areas of medical devices, biotechnology, and pharmaceuticals. She provides patent and trademark counseling and portfolio management, and provides opinions regarding patentability, freedom to operate, infringement, and validity. Tanya works with a variety of medical device and biotechnology clients, including Fortune 500 companies, mid-size and startup companies, and university clients. She's authored a number of publications and given presentations on issues related to life sciences IP. So Tanya, I will hand it over to you, and thank you for joining us today.
Thank you, Carolyn, and thank you for having me. One quick thing is I can't see anybody else except you, Carolyn. So
Okay.
That's fine, but I just wanted, if someone wants to ask a question or raise their hand, just let me know in case I can't see them.
Yep, I will.
Okay, so yeah, as Carolyn said, I am an IP attorney. Most of my work is patent work, but I do a little bit of trademark work as well. And my patent practice focuses mainly on medical devices. My technical background is that I actually graduated from medical school and then decided to go to law school. So I have an MD and a JD, which really allows me to understand the medical devices and as well as some of the biotech and pharmaceutical stuff that I work on. And so that works out well. But I like the little bit of trademark work that I do as well, because it gives me kind of a break from it's kind of more fun, less serious than the patent stuff. So I hope that this will be informative, and I thank you all for joining on a Friday afternoon. And as I said, I'll have a talk for about 30 or 40 minutes, and then we'll have time for questions. But anybody, if you have a question, feel free to interrupt me. Carolyn, let me know if I don't see someone who's raising their hand or has a question. So we're going to just talk about trademark basics today, and hopefully this is not going to be too basic for you. We're going to talk about what a trademark is. We're going to talk about why you should register your trademark with the USPTO. We're going to talk about choosing a trademark, the filing and application process, as well as protecting your trademark rights. So these are all different examples of trademarks, which are pretty well known around the world. And when you take a look at these trademarks, what do you think of? You think of Coca-Cola, you think of soft drinks. Nike, you think of shoes. Google, you think of a search engine. Amazon, you think of an online retail service. Target, you think of a big box retail department store. McDonald's, you think of fast food. Apple, computers. So every time you see or hear or experience one of these trademarks, it automatically brings to mind a very specific set of goods and services. And that relationship between the trademark and the underlying goods and services is important, because a trademark is always tied to very specific goods and services. And that's because a trademark identifies the source of goods and services, and it distinguishes them from goods and services of another party. So for example, when you are at a restaurant and you say to the waiter, "I'll have a Coke, please," and the waiter says, "Is Pepsi okay?" You are using the Coke trademark to identify the source of goods you want, and the waiter is using the Pepsi trademark to identify the source of goods that the restaurant provides. And both of you are using these trademarks to distinguish their respective goods from one another. So think about what you use to identify the source of your goods and services. What do you use to distinguish them from your competitors' goods and services? And what we're really talking about here is your brand. And a trademark provides legal protection for various components of your brand. So now let's talk about what a trademark is not. It does not mean that you legally own a word or a phrase. It does not mean that you can stop others from using a word or a phrase. And it does not mean that people owe you money for using a word or a phrase. So let's think about the word Apple. So Apple Inc. has a registered trademark for the word Apple when used with computers, iPhones, earbuds, other electronics. But it doesn't mean that Apple Inc. owns the word Apple. So anyone can say Apple or buy an apple or eat an apple, right? And they don't owe Apple Inc. any money for saying or buying or eating an apple. So the trademark Apple just means that Apple Inc. has the exclusive right to use the word Apple as a brand for their computers and smartphones. So let's talk about terminology for a minute. So you might have heard of service marks as well as trademarks, but there isn't really a difference. Technically, a trademark indicates the source of goods and a service mark indicates the source of services. But the distinction is kind of academic because the word trademark or simply mark encompasses both goods and services. So going back to Amazon, for example, the trademark Amazon may technically be a service mark, but it's also fine to just refer to it as a trademark. So let's talk about types of trademarks. There are multiple types of trademarks, and a single business can own and use multiple types of trademarks. The most common types are brand names, slogans, and logos. And so a business might register its brand name, its slogan, its logo, and/or some combination of all of the above. So here's an example, Nike, shown on the left side of the slide in what is called the standard character format. So this is Time New Roman font, I believe, and it's just black and white, and it is just the basic word, also referred to as word mark. You can see on the right side, it's shown in a stylized format, and that's a specialized format, but the standard character format actually provides the broadest protection for a brand name because you are not only protecting the word, but you're protecting it no matter how you use it, regardless of size or font or color, or things like that. So, oh, is there something in the chat?
That was just me.
Oh, okay. Sorry. So same for Nike's slogan, just do it. It's shown on the left in standard character format. And in the middle here, you can see the Nike swoosh here in black and white, but it could also be in color. And over on the right is a special format of the Nike brand name, slogan, and logo together in the particular font and size that you're used to seeing it in. So the most common types of trademarks are brand names, slogans, and logos. But remember that anything can be a trademark as long as it indicates the source of goods and services. So now let's talk about some less common or non-traditional types of trademarks. These include sound, color, scent, or smell, motion, holograms, and configuration or shape. So for example, the 3 chimes for NBC, I'm not a very good singer, so I'm not going to sing it, but you all know what I'm talking about when I talk about the 3 chimes that indicate an NBC broadcast is beginning. I'm sure you've heard that before. Another example is the bird's egg blue box for Tiffany's jewelry and the shape of a Coca-Cola bottle. So the use of these sounds, colors, and shapes in association with their source goods or services allows them to function as trademarks. But again, it doesn't mean that Tiffany's owns this color blue or that NBC owns the chime sound. Okay, we're going to talk about why you might want to register your trademark with the USPTO. But first, let's talk briefly about the various kinds of trademark rights and where they come from. The 2 most common types of trademark rights are common law rights and federal registration rights, which we'll discuss here. But I also want to point out that there are state trademark registration rights and international trademark registration rights. And that's probably a topic for another presentation, but just so you're aware of those. So common law trademark rights are the simplest type, and they are rights that are created as soon as you begin to use something as a trademark. And that's all you have to do is just use the trademark. So common law rights are actually state by state. And so the rights are created under state law and limited to the geographic area in which they're being used. So if you want broader protection, such as, protection across the country, you need to pursue federal registration of your trademark. Federal registration rights are created as soon as you register your trademark with the USPTO. And they create a legal presumption that you own the trademark and have the right to use it throughout the US and its territories. Federal registration rights allow you to bring legal action concerning your trademark in federal court, which is a huge benefit. Let's say if someone in Alaska is infringing your mark, you don't have to go to Alaska to sue them. You can sue them in federal court. Another benefit is that you can record your registration with the US Customs and Border Protection, and they can try and stop counterfeit or infringing goods from coming into the country. So a lot of times electronics or software, clothes, shoes, items such as that are big ticket counterfeit items. And CBP can be on the lookout for these counterfeit goods coming in at US ports or borders if they're aware of your trademark registration. Yet another benefit of federal registration is that you can use your US application or registration as a basis for filing in another country. So there's no such thing as an international trademark. Trademark rights are country specific. But if you have federal registration rights, US federal registration rights, you can take advantage of what is known as the Madrid Protocol and to try to extend your protection to other countries. And this is going to be a lot cheaper and easier than starting from scratch in each individual country in which you're seeking protection. And finally, once your trademark is federally registered, you can use the R in circle symbol. There's no need to use the TM or the SM symbols in conjunction with federal registrations. So now let's talk about how to select a trademark. You want to select a trademark that is federally registrable by a trademark examiner at the USPTO, and not all are. And then after it's registered, you want it to be legally protectable. And again, not all are. And this is because of common law rights. And someone, may turn up and say, oh, I've been using this mark since, 1905. And so you may not be aware of that. So it's something that you need to consider before you file your trademark application. So there are two main concepts to consider in making sure that your trademark is both federally registrable and legally protectable. And those are likelihood of confusion and strength of the trademark. And during the trademark examination process, these concepts come up in the form of likelihood of confusion refusals, and descriptiveness refusals. So let's first talk about likelihood of confusion. The USPTO will not register a trademark that is likely to cause confusion with a trademark that is already registered or applied for. And that's because what a trademark does, as we talked about, is indicate the source of goods and services. And if it's causing consumer confusion, then it's not really serving that purpose. So when you apply to register a trademark, the examining trademark attorney will look in the PTO's database to determine if there's a likelihood of confusion, which really comes down to two questions. Is the trademark confusingly similar to another registered mark? And if so, are the goods or services related? And if both are true, the examining attorney will refuse registration. But notice that both of these things need to be true in order for the trademark to be refused. So if two trademarks are confusingly similar or even identical, but the goods and services are not related, then it will be possible to register both marks. And we'll see some examples of this in a few minutes.
We have a question.
Oh,
Actually,
yep.
a couple.
Yeah.
Can you register a trademark on the same name if the previous trademark is dead?
It goes back to, whether okay, so if it's the same name, it is going to be confusingly similar, but it depends on whether or not the goods and services are related. And if the previous trademark is dead, then I think that that would probably that would probably weigh in your favor. It depends. I think it depends on whether the public is still going to be confused by that.
Okay.
So.
Okay, and then I think you started to get into this one, but can you register the same trademark for a different class of good or service?
Yes, so we'll talk about classes a little bit later. But yeah, if they're different classes, they're likely unrelated goods or services. So that would weigh in favor of registration.
Thanks.
Sure. So let's look at some examples. Let's say that someone wants to register the trademark Arrow for gloves, and the examining trademark attorney looks in the database and finds the trademark Arrow is registered for hats. Are the marks confusingly similar? Yes, they're identical. Are gloves related to hats? Yes, it is likely that both gloves and hats are made by the same company. So this trademark application would likely be refused. Now let's change the scenario a bit and say that you want to register the trademark Arrow for gloves, but there's an existing registration for Arrow, AIRO, for hats. Are the marks confusingly similar? Yes. Even though they look different, they sound similar. Are gloves related to hats? Yes. So again, this would likely result in a refusal. But what about this example? So you want to register Aero for gloves, but Aero, AIRO, is already registered for tennis rackets. So here, Aero and Aero are confusingly similar, but are gloves related to tennis rackets? Well, probably not, but it would be the job of the trademark examining attorney to do some research to see if companies that make gloves also make tennis rackets, and whether consumers would be confused by these two marks. So here are some kind of fun examples of identical or nearly identical trademarks that are both registerable because they cover goods and services that are not related. So Dove soap and Dove chocolate, identical marks, but consumers are not confused because you wouldn't eat Dove soap and you wouldn't, use Dove chocolate to wash yourself. So that's an example of two identical marks being registerable because they cover unrelated goods and goods. Same thing for Domino's sugar and Domino's pizza, although here they're both kind of in the food category. You would use Domino's, you would not use Domino's pizza to bake, and you wouldn't eat Domino's sugar for dinner, hopefully. So those are completely different goods and services, or goods in this case. Again, Delta Airlines and Delta Dental, these are both able to be registered because they cover different services and they don't create consumer confusion. So the way that you can determine whether a mark is registerable based on likelihood of confusion is by doing a trademark clearance search. And this can be done through the USPTO database, which is publicly available, and also on the internet to check for common law use of trademarks. You could also hire an attorney, a trademark attorney, to do a full clearance search using various other search tools and databases. Now let's talk about the strength of a trademark, which is the second thing to consider when looking at whether a mark is registrable, it's a hard word to say, and protectable. So the USPTO is not going to register marks that fail to indicate the source of goods and services, because that's really the point of a trademark. So if a trademark is merely describing goods and services, it's not really functioning as a trademark because it's not indicating the source of the goods and services. For example, let's say you're a Minnesota farmer and you grow a new variety of apple in addition to Honeycrisp, which is Minnesota is known for. Do you guys know Honeycrisp apples in Kentucky? Yes, they were developed in Minnesota. So if you discovered a new variety of apple and you wanted to name it Apple, A-P-P-L-E, would you be able to register Apple as a brand name? No, because it would be merely descriptive. So here's a little chart of the descriptiveness spectrum. At the bottom of the spectrum are weak trademarks, including generic terms, which really aren't even trademarks at all, like spoon, light beer, thermos, escalator. These are not registerable. The next rung up is descriptive, which are also not registerable, at least on the principal register. And where you really want to be with your mark is in the suggestive or arbitrary and fanciful zones, because these provide the strongest protection and are registerable. So a suggestive trademark suggests something about the goods or services, but it doesn't really describe it. So copper tone sun lotion, for example, it suggests that if you put it on and you go out in the sun, you get copper tone skin. But your brain still needs to make a leap between the mark and the goods and services which it's covering. A fanciful mark is an invented word with no meaning in any language. So like Kodak or Xerox. And an arbitrary mark is an actual word, but the word has no association with the goods or services, such as Apple for computer or Ivory for soap. Okay, let's move on to the filing process and timeline. This graphic is taken from the USPTO website, and it shows the basic breakdown of what the application process looks like. So you file your trademark application with the USPTO. It gets examined by a trademark examining attorney. It then gets published, and then there's a 30-day opposition period, which we'll touch on later. And then if everything goes well, your trademark will register. And this whole process typically takes about 12 to 18 months, although these days it's usually closer to 18 months since the trademark office has had a pretty big backlog since the start of the pandemic. Is there a question or no?
Yeah, it was back on likelihood of confusion.
Oh, sorry.
That's okay. No, I think she just typed it in. So it was, does likelihood of confusion just apply to other federal trademarks, or can it apply where there's a common law trademark owned by one party and a different party seeks to register the same word as a federal trademark?
Yeah, it can apply to common law trademarks as well. So trademark applications are filed using the Trademark Electronic Application System, or TEAS. And there are two filing options, TEAS Plus and TEAS Standard. TEAS Plus allows you to save $100 on the filing fees per class of goods or services. But you need to use a pre-approved goods and services description from the Trademark ID manual. So in some cases, there might not be an accurate description in the Trademark ID manual for your specific goods and services, in which case you just need to go the standard route and draft your own description of your goods and services. So as I mentioned, the TEAS Plus filing fee is $100 cheaper. It's $250 rather than $350 per class. And when we talk about international class, what we're actually talking about is 45 different classes that are categories of goods and services that were established according to the NICE agreement, which is published by KYIPA. So the NICE classification system has been used for all trademark applications filed after 1973. So we won't go into too much detail here, but basically each trademark application has to be classified in one or more appropriate classes. And the more classes that you want to seek protection under, the more expensive it will be to file, because you'll have to pay a filing fee for each class. So, for example, Adidas sells soccer balls, right? But they also sell T-shirts with their brand name. So they've registered their trademark under at least two separate classes, and probably a lot more. But that's just an illustration of the different classes that you can have for a single mark. So let's talk about the basic application requirements for trademarks. You need a clear drawing of the trademark, and what is meant by a drawing is the standard character black and white representation of your mark. You have to include a description of the goods and services used with the trademark. You need to include a filing basis for each good or service, and typically filing basis is either actual use or intent to use. And you need to include contact information for the applicant or their attorney. And of course, you need to include the filing fees. So examination of a trademark application is kind of similar to the patent process in that the trademark examining attorney typically issues an office action with grounds of refusal, which the applicant then must respond to in the back and forth process. And as we talked about before, two of the most common grounds for refusal are likelihood of confusion and being merely descriptive. There are other reasons as well that your trademark could be refused. For example, if it's geographically descriptive, if it's primarily a surname, if your specimen doesn't support use, or if you're using it in an ornamental manner, like splashing it across a t-shirt. So once the examining attorney has examined your application and you've overcome any refusals and everything looks okay, the examining attorney will approve your mark for publication. Your mark then appears in the USPTO's official gazette, which is now exclusively electronic. And this starts a 30-day period in which the public is allowed to file an opposition if they don't think your trademark should register, for example, because it would infringe one of their marks. However, most trademarks move through the opposition period without a whole lot of oppositions being filed. It's pretty rare to see. So following the opposition period, the application moves forward, and the way that it moves forward depends on what the filing basis is. So as I mentioned a few slides back, there are two main filing bases. One of them is when your mark is based upon actual use in commerce, and it requires that the mark be used in commerce across state lines, so in interstate commerce. If this is the basis under which you filed, your application will move to registration after the opposition period. However, if you have filed under an intent to use basis, meaning that you are not yet using your mark in interstate commerce, but you intend to, then your application moves forward to allowance. And you have 6 months after receiving a notice of allowance to file what is called a statement of use, indicating that now you have started to use the mark in interstate commerce, or to file a request for an extension of time. And so you can take up to 5 6-month extensions, which ends up working out to 3 years total that you can have between receiving the notice of allowance and filing the statement of use. So I think I see a question.
Yeah. So can a trademark be challenged during the opposition period for existing common law use?
For existing common law use, I don't think it can be. I mean, it wouldn't. The federal registration wouldn't be challenged because the common law use would be out, under a different. That it wouldn't be challenged on the basis of, the application to register federally. After your trademark registers, it's up to you to enforce your own trademark rights. The USPTO does not police or enforce trademarks. So there are companies out there that you can pay to monitor use of your trademark, or you can do it yourself. But if you aren't going to enforce your mark and protect it from infringement, then it probably isn't that valuable. The other thing to keep in mind is that you must file the required post-registration documents. So a trademark can really last forever if you continue to use it in interstate commerce and you continue to file your post-registration documents with the PTO. And we won't really get into the details here, but the basic post-registration requirements include a Section 8 declaration of use that's due between the 5th and 6th years after registration. and a combined Section 8 declaration of use and Section 9 application for renewal, which is due between the 9th and 10th years after registration, and then every 10 years thereafter. So as I wrap up here, I want to point out some helpful USPTO resources. The USPTO has many great resources for trademarks. It's very, their website is very user-friendly. They have videos and tutorials. And I'd really encourage you to take a look at it if you're interested. And now we have some time for questions, and that's my contact information.
Thanks, Tanya.
Sure.
Let me check and see. Oh, we do have a hand raised. Sorry if you have had that. Let me unmute you, Kyle. Okay, you should be able to talk now, Kyle, if you want to ask your question.
Oh, I'm sorry, that was a mistake.
Okay, sorry about that. Okay. We have any other questions that anyone wanted to ask, either in Q&A or chat, or we can unmute you if you need. Okay, not seeing any. I will add too to your USPTO resources. They do kind of an in-depth boot camp that I've seen. They have it periodically. So if anyone's interested in doing a more deep dive, that's a good resource too. You can check out their website and they post that. We do have a few questions. So Sarah's asking, going back to the earlier opposition question, can the owner of a common law trademark oppose a federal application based on its common law use?
Yes. So anyone in the public can file an opposition, and if that's the grounds that you have prior common law rights, that's an acceptable grounds for opposition.
Okay. And then we have one from Megan. Can you talk a little bit about getting a trademark outside of the US? And I will add on this one, we have a presentation coming up in December. Just stay tuned for that one, where we're going to talk more about European and UK trademark rights. But Tanya, do you have just a quick summary on getting trademark protection outside of the US?
Yeah, so I mean, so this presentation was focused on US, but what I would say is that, going back to what I mentioned, the Madrid Protocol, and that allows you to claim priority back to your US application. So if within 6 months after filing your US application, you want to file an application in a foreign country, you can do so and claim priority back to your US filing date. So that's a pretty common route for a lot of US companies anyway, who end up filing first their US trademark and then are interested in international filings as well.
Okay. And then I see one more. Can you comment on the risks of using the registered symbol before approval of the application?
Well, that's obviously not appropriate. And someone who would oppose your use could sue you for that. I don't have experience with that particular situation, but I know that when I do. There's one case where my client had prematurely put that on their website or something, and the trademark attorney pointed out in an office action that they really shouldn't be doing that. And so it was kind of like a warning. I don't know what action they take specifically, since they're not an enforcement agency. If you didn't take it off, but I of course advise my client, it's not okay to have that on your website if you're not actually registered. But so the trademark attorneys will check for it. I don't know the exact consequences of keeping it up there and after you've been warned to take it down.
Okay, well, don't see any more questions, so I'll wrap up. Tanya, did you have anything to close?
Nope, just that, thank you for having me today. And if you have any trademark questions, or if you have patent questions, feel free to reach out.
Okay, thanks everybody for joining. Happy Friday and happy early Halloween. And thank you, Tanya, so much for giving us this great presentation. As I mentioned earlier, we do have our next one coming up on December 2nd, and that's going to be over European and UK trademarks. So watch for the invite to that. Thanks everybody again for joining us. And thanks so much, Tanya.
Thanks.
Have a great weekend, everyone.